All right. Hello, everybody. This is Audrey Button from Safe Harbors of the Finger Lakes. I'm here with Ashilee Dickinson from Legal Assistance of Western New York, and I'll let her do an introduction as well. But we're just covering some Title IX information today, also to address the changes that have occurred recently that were enacted back in August 14th of 2020 to be exact. So Ashilee's here to help us kind of get a deeper dive into what Title IX is, how the Title IX process looks, and an investigation and all of that. So to go ahead and do some introductions, like I said, my name is Audrey Button. I work at Safe Harbors of the Finger Lakes. I use pronouns she, her, hers. I'm a college specialist, so I do advocacy and prevention education. So I work with victims and survivors of, sexual assault, domestic violence. I also work with people who experience child abuse and human trafficking. For more information about what we do at Safe Harbors, you can always go to our website, which I'll address at the end of this presentation as well, but it's www.shflny.org. And I'll go ahead and let Ashilee introduce herself.
My name is Ashilee Dickinson, and I am a staff attorney with Legal Assistance of Western New York. I focus specifically on working with survivors, victims of domestic violence and sexual assault. So that entails the Title IX process through our 14-county region. I also work with survivors in family court, addressing orders of protection, custody issues.
Okay, and I'll just kind of get into some background information before we kind of dive into the deeper stuff about Title IX specifically, what that looks like, investigations, etc. So just a basic Title IX background. It was came into law in 1972, and according to the law, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to the discrimination under any education program or activity receiving federal financial assistance. It's a little wordy, but basically what that means is that this applies to any educational institution that receives any sort of federal funding, and it's just protection of anyone, so they're not discriminated based on any sort of sex in college campuses or schools of any sort, educational institutions. To go a little bit further into Title IX, it's kind of changed over the years. Things have been added or removed or changed, etc. Obama in 2011 issued some guidance about schools' obligations regarding sexual assaults as civil rights matters under Title IX. And he also provided some further guidance regarding LGBTQ students. And then as of now, which is what we're going to be talking about a lot today, is the changes that were made this year. So on May 7th, Secretary of Education Betsy DeVos released the new revised changes under Title IX. So these were enacted and across all schools, elementary, secondary, and higher education, which had to go into effect on August 14th of 2020. So another important thing to also mention before we get into everything is the Violence Against Women Act, which is also known as VAWA. This was originally enacted in 1994. The purpose of this was to improve the criminal justice response to dating and domestic violence and sexual violence, etc., and also improve more access to community resources. This Act was reauthorized in 2000, 2005, and 2013 to add to it and add some important information in regards to, protecting underserved populations like Native Americans, immigrants, people with disabilities, LGBTQ plus individuals, etc. There's also focused on, getting more access to community resources like shelters, rape crisis centers, just any sort of services that are necessary for those experiencing domestic or sexual violence. This could also include just, making sure these people have access to these, including immigrants or people who have undocumented statuses, to make sure that they're safe. So they're considered a victim of a crime. So there was the creation of U&T visas. There's also been a, push to focus on people who've experienced human trafficking as well. And then so we'll go into a little bit about the Cleary Act. So this was named after Jean Cleary. She was a college student who was sexually assaulted and killed in her own dorm room. And so her parents and family pushed to have this act created, which is, requiring schools to report crimes that occur on campus. And I say on campus in quote, because that could be physically on campus, around campus, and in some instances off campus, anything that will affect the student population in the greater college community. So these information about crimes that occur on campus or around campus must be available in the annual security report, which is also called the ASR, which should be found on your school's website. And then just making sure schools are sending out those timely warnings to the school community if there are risks of safety for students on campus. This additionally, was extended with the Campus Save Act in 2013, which provided specific information about the Sexual Assault Victim Bill of Rights, which included information about how students can report any sort of sexual assault that they can report to outside agencies, including law enforcement, and how that goes. And so it also included not only sexual assault and domestic violence, but dating violence and stalking were included under the Cleary Act, which was expanded by the Campus Save Act in 2013. So then also what's important, this is a New York State specific law. It was Enough is Enough. It was signed into law July 7th in 2015 by Governor Cuomo. This was important because it created a uniform definition of consent. Because it usually varied by campus to campus, this just created a uniform definition of what consent is. And then along with that, to encourage people to report incidents of sexual assault or any sort of violence, including domestic violence, stalking, they created an amnesty policy, which each of your campus should have a written amnesty policy, which is just to encourage reporting incidents of sexual assault. So usually people tend not to want to report, especially if they're breaking school policies like underage drinking, use of drugs, things like that. So this is encouraging people, to report those incidents without fear of getting in trouble themselves. So there's certain policies along that line. And if you had any questions or concerns about that specifically, you could reach out to Title IX on campus, or also reach out to us to go through what that amnesty policy looks like. So there's also a Student Bill of Rights from Enough is Enough, which informs students of their legal rights and how to get access to any sort of resources on campus or off campus. And there's been a push for prevention education and training for students, staff, and faculty, even administrators on campus. And then there was also the creation of the New York State Police Campus Sexual Assault Victims Unit, which they're specifically trained to work with people who have experienced any sort of violence. This is not just sexual violence, but domestic violence, stalking, anything related to that. They work with local police or on-campus police to start an investigation or make sure students are getting the resources they need. All right, so we're going into the questions. So this is where I'm going to have Ashley jump in with some of her own knowledge as, a lawyer, because she specifically does Title IX stuff more than probably I, because I'm not a lawyer. So we'll go ahead and have her go through some of this important information. So we'll go ahead and start with some definitions. And I don't know if you want to go ahead and define each of these words up here, Ashley, for people.
Yeah, so first I want to start off with, we're just talking about the new Title IX rules and regulations for college campuses. The rules and regulations do differentiate a little bit for K through 12 in some areas. So we're going to focus specifically on colleges, universities. Also, because New York has Enough is Enough, they have a policy specifically to conform for the new rules and regulations underneath Title IX, but then some schools have Enough is Enough policies as well to conform to the law in New York State. So again, we're going to focus specifically just on the Title IX and not how that could impact Enough is Enough either. So starting with some definitions, you'll hear complainant or reporting party, depending on the school. that is the person that's making the report, the person who is the alleged victim of the assault. Then you have the respondent or responding party, again, depending on the school, and that is the person who has allegedly committed the acts of sexual assault, sexual violence against the alleged victim, against the complainant. Then we have the formal complaint, and this is the document that's either signed by the complainant or by Title IX that sets forth the allegations of the sexual harassment. So it'll give the details about when, who's involved, where, and then details about the assault itself or the harassment. Then we have the supporting measures, and the supporting measures are individual services that are provided to the complainant, but they cannot be punitive to the respondent. So we're talking like counseling for the complainant, deadline extensions, other course-related adjustments, modifying work schedules or class schedules, escorting the complainant across campus, mutual restrictions on contact between the parties. But it cannot be punitive to the respondent. So I think like changing housing, like making the respondent move housing may be considered punitive or overly burdensome to the respondent.
So,
Sorry.
You're okay,
Ashley.
So to go into question 2, can you describe how the definition of sexual harassment has changed for Title IX?
So the new definition of sexual harassment, it must meet one of these 3 criteria: quid pro quo, unwelcome conduct that a reasonable person would find severe and pervasive and objectively offensive, that it denies a person equal access to their education, or sexual assault defined by Cleary, dating or it's dating violence, domestic violence, and stalking under VAWA. So to start with a quid quo, if I could say it today, that is when an employee is sexually harassing a student. So they're in a position of power. So for example, that would be like a professor asking for a sexual favor in exchange for a better grade. Then we have the severe and pervasive, and that second category there. And this is very, it's a gray area, so to speak. So we're looking at a reasonable person standard. What would a reasonable person find objectively offensive? So it's how unwelcome is this behavior? How severe is this behavior? That it creates an environment that it's like a hostile environment that prevents a person from getting their education. So they're looking at how bad the assault was or the harassment is, if it's a violent assault, how many times has this occurred? If it's only happened one time, more than likely it's going to be deemed not severe or pervasive enough. Now this is a little bit different definition than maybe like harassment in the workplace where it's severe or pervasive. This is severe and pervasive. So it has to be both. Then the definitions of Cleary, under Cleary and VAWA, they're very straightforward in each act. You could go look at those, but it has to meet the elements contained within those 2 documents. Let me see if this works.
Perfect.
There we go.
Question 3. In order for a school to respond to sexual harassment, where must the harassment take place?
So before I answer that question, going back to the last slide really quick.
Of course.
Just if a harassment or an assault doesn't meet those definitions, does it mean that it may not fall within some other policy or violation of the school? So that's up for a school to look at.
That's a great point. No, you're great. No, that was great to add. Thank you, Ashley. And so,
Question 3.
yeah, we'll go into this. And where must this harassment take place for it to apply?
So it must take place on campus or college-owned property. So if they have maybe a sports center or something like that that's not attached to the main campus, that college-owned property, if it happens on that property, would fall within Title IX. So this also includes recognized fraternities and sororities of the school. So if the fraternity and sorority is not recognized by the school, then it doesn't fall within Title IX. It must take place during a college programs or activities, and it must occur in the United States. So you're on a sporting event that's part of the college's programs or activities. That's it takes place on a college campus. It's in the United States. That would fall within Title IX. Off-campus housing, online, study abroad programs, and like I said, the non-recognized fraternities and sororities do not count under Title IX. That does not mean that, again, it could fall within another campus policy violation.
Question number 4. So who should students report to, and what happens if a student does not report to the proper person?
So students have to report to the Title IX coordinator or someone at the institution who has the authority to take corrective measures. So that would be a dean, for example. So maybe an employer on campus, because they have been given the authority by the school to take corrective measures in their own right or in their own job. This would probably not include professors or coaches. So under the old Title IX guidance, it was good enough if the school had constructive notice, meaning that a report has been made to a responsible employee, and they should have known they knew or reasonably should have known about the sexual harassment. That was considered good enough. So students could report to someone they trusted, a coach, a professor, residential staff. That is no longer the case. You have to make the report to the proper person for the school to be considered to have actual knowledge, meaning they know about the sexual harassment, therefore they have a duty to respond to it. Once the institution has actual knowledge, they are obligated to institute supportive measures for the complainant, but they're not necessarily obligated to investigate. That obligation to investigate is once a formal complaint is signed and a complainant wishes to move forward with the investigation. If a report is made to the coach, again, there's no duty for a school to do anything.
All right.
There it goes.
Yay. Question 5. So what must a complainant's enrollment status be at the time of filing?
A complainant must be enrolled in school or attempting to participate in their education when a formal complaint is filed. So we know sometimes a victim survivor, after experiencing sexual assault, sexual harassment, it's hard to continue their education. They withdraw, they take a leave of absence, maybe they transfer. If that occurs before the complainant files, then the school must dismiss the complaint. They have to be enrolled and attempting to participate in their education. So taking part of those supportive measures, extremely important. Get those extensions, maybe get that class schedule rearranged, get the counseling services so you can continue, so complainants can continue participating in their education and file a complaint. Now, going to the supportive services, you do not have to file a formal complaint to get those services. So if a complainant is no longer participating or attempting to participate in their education after a formal complaint has been filed, then the investigation is to continue. So the investigation, which we'll talk about later, and a hearing.
So question number 6. So what if the respondent is no longer enrolled in school?
So this is discretionary for the school itself. The school may dismiss a formal complaint or allegations if the respondent is no longer enrolled in school. So formal complaint is filed, complainant has done, they're participating in their education or attempting to, but respondent decides, I'll just drop out, or maybe they graduate, or whatever the case may be, then the school on their discretion may dismiss their complaint. So complainant could totally do everything that they're supposed to do, but the respondent decides to whatever they choose to do, that's the end of the case, potentially. And it's going to depend, I think, on the school's ability to collect evidence, to conduct their investigation. If the respondent no longer being enrolled in school really impedes that ability, then I think that increases the chance that it may be dismissed. It also, I think, depending on the level of maybe violence or the level of the harassment, that would also play a role into whether or not the formal complaint is dismissed.
So question number 7, for a college campus to begin an investigation under the new Title IX rules and regulations, you must have to do what?
You must have all of these things. The complainant must have stayed. The respondent must stay. You must file a report with the proper person. It has to occur at the right place or on, college campus, and it must be severe enough. Schools must dismiss allegations of conduct that do not meet this, that do not contain these factors, or they don't fall within the proper definition of sexual harassment. If they don't fall within Title IX, the new rules and regulations, a school may pursue it underneath some other policy. So in New York's enough is enough.
So question number 8. So what must an institution do during their grievance process?
So they have to treat the complainants and the respondents equally. They have to give them the same amount of time to respond to pleadings as the evidence, the final investigation report. They must provide remedies anytime a respondent is found responsible, and treat the respondents equally by not imposing disciplinary action or sanctions if they're not found responsible. If a respondent is found responsible, the remedies must be designed to maintain the complainant's equal access to education, which may also include supportive measures. So they require the evaluation of the evidence. You know, we put on blinders, so to speak, to evaluate the evidence. That's in the case. We don't weigh one over the other. So everything is supposed to be equal. The investigation, the schools are supposed to be a neutral fact finder, neutral investigator.
So this goes into question number 9. So what does the Title IX investigation entail?
So institutions must investigate the allegations in the formal complaint and must provide written notice to the parties of the allegations upon receipt of the formal complaint. Now, it's normally the complainant who's signing the formal complaint, but if the allegations are severe enough and the complainant may not want to move forward, Title IX may sign that complaint and pursue its own investigation, depending on the allegations. Schools are to maintain the burden of investigating and the burden of proof, not the parties. So it's not on the complainant to prove that they've been sexually assaulted. It's not on the respondent to prove they didn't. It's the burden is on the school to investigate and make a determination. It's not one case or one party proving their case over the other. Parties have the ability to present inculpatory, which is proving they did the respondent committed this crime or the allegations, and exculpatory evidence, which is the respondent saying, I didn't do this, and here's my evidence, and present witnesses. Schools cannot prevent the parties from discussing the allegations or gathering evidence. There's no gag order, so to speak. Parties may select an advisor of their choice to work with during the Title IX process. The advisor can be anybody the party chooses. It could be an advocate. It could be an attorney. It could be their coach, a professor. We'll talk a little bit more when we get into the hearing process, or a little bit more when we talk about the hearing and the cross-examination on how important it might be to have an attorney with you for that because of the cross-examination. But it can be anybody the party chooses. If a party does not have an advisor come the day of the hearing, the school must appoint them one. And it's the school's choice, they're free, but they have to have an advisor. And again, that'll be made clear a little bit further down the road why that is. The parties and their advisors have the ability to inspect, review, and respond to evidence submitted. That must be done within 10 days. So you get it, within 10 days you have to respond saying, I think this evidence is irrelevant and this is why. So any irrelevant evidence is kept out of the hearing. And the school makes that final determination. Once the parties have the opportunity to review the evidence, submit their response, then an investigation report is issued. And that summarizes the relevant evidence, the witness statements, the statements of the parties, and comments to that must be made within 10 days of receipt of that investigation report.
So question number 10. So what protections do parties have in regards to their medical and past sexual history?
So there's HIPAA, which is a federal law that protects people's medical, psychological records, or records that fall within maybe the same kind of umbrella. So schools cannot just go and get those. Again, they're federally protected. Schools can ask for a party maybe to waive that, and that has to be voluntary and written consent. So something, if a rape kit is done or an examination after a sexual assault is completed, that might be an instance when the school needs those records as part of their Title IX investigation. So you can limit the information that the school receives on that consent to get those records. There's also the rape shield laws, and this forbids a respondent from bringing in a complainant's past sexual history into an investigation. So a respondent can't come in and say, well, I have an ex-boyfriend who says, the complainant likes to engage in this type of sexual activity to prove their case. That is kept out. However, if the parties have had prior sexual relations, that may be used to show maybe a history. It doesn't necessarily mean the complainant had consented this time or things, this wasn't a sexual assault, but the respondent can use that to show a history. It can also be brought in, the respondent can use this information if they're trying to prove that they didn't commit the assault, someone else has. Rape shield laws are specifically for complainants. They are not afforded, respondents are not afforded the same protection because it's historically the complainant's sexual history that's coming into question.
So this goes into question 11. So what is a live hearing with cross-examination?
So a live hearing is everything's done in real time. The cross-examination, the taking of the evidence, it's all done in real time. If a party asks for maybe to be separated in different rooms than the respondent, they can connect them by technology. That request can be granted, that can happen. It can also be done over Zoom or any other media platform, so that the parties don't have contact. But it has to be live, it has to be done in real time. The cross-examination is, it's something new, it's something that was fought about, and advocates across the country wrote a lot of opinions asking this not to be included in the new Title IX's rules and regulations. Unfortunately, it's something that stayed. And at first it was the party themselves could cross-examine the other party. That was changed, so now it's the party's advisors. And this is where sometimes having an attorney who's trained to do this is beneficial. It's not to say that an advocate can't learn that, they can't work with an attorney to do that. But it is something that, again, it's kind of not really specialized, but attorneys, again, are trained in that. What's going to happen in the cross-examination is questions will be asked by the party's advisor to the other party. The advisor will ask questions of the witnesses, and they're allowed to challenge credibility. Schools have put into place decorum rules, so parties' advisors are not getting nasty to the person that they're questioning. That's a big thing. Sometimes respondents will hire criminal defense attorneys, and criminal defense attorneys can be nasty to victims. So that's, the decorum rules are there to prevent that. So everybody's treated fairly, equitably. This is not a courtroom. Only relevant questions may be addressed. And so how that's going to take place is a question will be asked by the party's advisor. The decision maker will determine if it's relevant or not. They have to give a decision of if they decide it's not relevant. Then the other party, the person testifying, is able to answer that question. Used to be you could submit written questions. The decision maker would decide if that was relevant, and the decision maker would ask that question. That's no longer the process. If a party or witness does not submit to cross-examination at a hearing, the decision maker cannot use their statement when determining responsibility. It's like they haven't even given a statement. It's completely thrown out, so to speak. It can't be relied on at all. So they have to submit to cross-examination. And for a complainant, that can be terrifying.
So we can go to question number 12. So what are the standard of evidence that is used in a Title IX case?
So there's 3 standards of evidence, burdens of proof. We all know beyond a reasonable doubt for criminal law. That's not this. In Title IX, schools have the choice to use either preponderance of the evidence or clear and convincing to make a decision. So clear and convincing means that it is more likely than not that the allegations are true. So it's one step under the beyond a reasonable doubt, right? Preponderance of the evidence is just tipping the scales. So 49% says, 51% says it's happened, 49% says it hasn't. So we're just kind of tipping the scales to determine responsibility. And that's like the lowest burden of proof that you have. So the institution, the college, the school, is required to apply the same standard of evidence for all formal complaints of sexual harassment, whether the respondent is student or employee. Now, this can be an issue because some unions across the country have in their contracts a burden of proof for employee sexual harassment of clear and convincing because it is that higher burden. So schools are then required to use clear and convincing in their Title IX cases. Clear and convincing tilts the scales in favor of a respondent. It's harder to prove, meaning you need testimony, possibly witnesses, the evidence, all of that to show that the sexual assault has happened. So you are tilting the scales in favor of the respondent.
So the question 13, what would the appeal process look like for both parties?
Both parties are have the opportunity to take an appeal. So if a respondent is found responsible, they can take an appeal from that. If they're found not responsible, the complainant can take an appeal. Appeals can be started if there's a procedural irregularity, meaning something with the investigation, the hearing process was done incorrectly, that is, they can take an appeal for that. Newly discovered evidence. It has to be discovered after the hearing that would have changed the outcome. So if the evidence was available during the investigation and it wasn't offered, that is the fault of the party. They can't now appeal saying, oh, I have this new evidence. No, it's newly discovered. There was a conflict with the Title IX personnel. They didn't maintain that neutral investigation, that neutral platform. There was some kind of conflict with maybe the Title IX coordinator or investigation. They had some sort of bias. That is, those are grounds set out in Title IX for an appeal. Schools can offer other bases to appeal to both parties. It has to be to both parties. It can't be one or the other. The appeal is taken from the written decision of the decision maker. A written decision has to be made, laying out the facts of the case. Sorry, my mind just went blank.
You're okay.
The findings that the decision maker relied on, whether or not the respondent has been found responsible or not responsible, and if the respondent has been found responsible, what those sanctions are. And yeah, that's it.
So this could go into question 14. So what would an informal resolution look like?
So informal resolution is mediation. It's restorative justice for the parties, as long as both parties give voluntary, informed, written consent to the attempt to an informal resolution process. Sometimes these processes work, sometimes they don't. Mediation or even restorative justice can be very intimidating to a complainant because you are working with the respondent during these. It's communicating to the other party. It's having the other party acknowledge the assault and the harassment. So they can be taxing on a complainant. They can be hard process to go through. Institutions cannot require a complainant or either party to go through the informal resolution process as a condition to their enrollment, their employment, or their enjoyment of any other right. So instead of, a school can't force, say, to a complainant, well, we're going to withdraw your enrollment in our institution if you file the formal complaint and you don't go through with the informal resolution process. They can't do that. Schools are required to report Title IX investigations, their findings, any crimes on campus, like Audrey was talking about earlier. They have to report all that. So schools can't find ways to have a complainant not go through with a formal complaint process. At any time prior to reaching a resolution, any party has the right to withdraw from the informal resolution process and resume the grievance process and the investigation. Institutions cannot offer or facilitate an informal resolution process if the allegations involve an employee sexually assaulting or sexually harassing a student.
So question 15, what is retaliation?
So retaliation is words, actions that would constitute intimidation, threats, or coercion intended to pressure an individual into not participating or participating, providing false information or misleading information in a Title IX investigation. It can include abuse, violence, other forms of harassment, making false statements about the other person in print, or verbally with the intent of harming their reputation. Retaliation is expressly prohibited in Title IX. It's against, it can't be against the person making the formal complaint or a person who is participating in an investigation regarding that formal complaint. Retaliation can be considered if it adversely affects a person's education, living, or work environment because they've made a report or they're participating in that report. It's discouraging a person from making a report regarding criminal complaint, Title IX, anything like that. And retaliation takes many forms. It can be done by an individual or a group. It's not just the complainant or the respondent. Respondent's friends, complainant's friends, publishing something maybe in the school newspaper, laying out the fact, the allegations of the case, that can all be considered retaliation. It's something that you really want to watch out for. Complainants want to tell their story, but it's also protecting them and making sure that they're not going to receive a complaint for retaliation.
All right, so I'm sure we could go on for hours and hours about this stuff, but this is hopefully a good insight to, the basic understanding of Title IX and then these changes, because it is very complicated. It can be overwhelming, especially if you don't have a legal background, which thankfully Ashilee does. And Ashley's a great resource. But to also get more information, I have included the Title IX offices for the schools that we work in and their contact information. So as you see, Keuka College is up here, Hobart and William Smith, Finger Lakes Community College, and also, I'll go on to the next page, New York Chiropractic College and the Finger Lakes College of Nursing, and which is also known as Marion S. Wayland School of Practical Nursing. All of these schools should have a website with the Title IX coordinator's information and phone number and email, but that's also included on here. So if you had any questions regarding that, and like Ashley said, they're a neutral party, but they will provide that basic information of your rights and what you're supposed to know and access to resources as well. And they can always get you connected with us here at Safe Harbors as an advocate. I can provide support to anyone thinking about going through the process or not sure what they want to do. If they don't want to go through a Title IX process, there's other options in terms of a criminal process, or just trying to find just some general support and resources if they don't want to go through either process or one or the other or both. There's so many options. It can be overwhelming, so which is why it's great to reach out to your on-campus resources and off-campus resources, including me and Ashley. And I work with Ashley quite a bit, so I can get you connected with Ashley as well, which I usually do since she is a lawyer and I am not. So, and with that, I like to, provide our contact information. Like I said, my name is Audrey Button. I work at Safe Harbors. There's my office phone number and email, and feel free to reach out for any questions. And I'll let Ashley wrap up as well.
Yeah, feel free to reach out. I'm happy to talk to anybody about their options, what the Title IX process would look like. I always give the complainant, I only work with complainants, so I always give the complainant their option if they want to work with me. Again, my services are free. I'm grant funded, so complainants don't have to pay for me to help them. If a complainant wants their advisor of choice to be an advocate, so Audrey, I'm always willing to work with that advocate to help them prepare the case, prepare for that cross-examine, tell them what they would be looking for. It's a little bit of a crash course, but I really leave options open to the complainant because it's their story. They are the ones that know the support that they will need. So it's really working with what the complainant needs in this time and making it work for them. And that's all about, they're taking control back, they're telling their story, and that's part of it.
Great. Thank you so much, Ashley, and thank you for everyone. Hopefully you'll get to use this and view it. We will be sharing it everywhere. But if you have
Have a good one.
You